The Supreme Court did not just tweak one gun case. It quietly changed the rulebook judges now use for gun laws across America. And while most people were not paying attention, 9 different gun law areas started shifting right under their feet. Pause. Quick question before we continue. Are you subscribed yet? Because this is exactly the kind of update that blindsides good people. One day you think your permit, your carry routine, and your rights all mean the same thing they did last year. The next day, a court ruling changes the answer. Well, if you care about staying legal and staying informed, hit subscribe right now. I break this stuff down in plain English, so you do not have to read court opinions for 6 hours on a Saturday. Here is what just happened. The big turning point was the Supreme Court's Bruen decision in 2022. That case said the government cannot defend a gun law just by saying, "We think this rule is good for safety." Instead, courts now ask a different question. Is this kind of law consistent with America's history of gun regulation? That one shift sounds technical. It is not. It changed everything. First thing you need to know, the court killed special need carry permit systems. In simple terms, states like New York used to say, you cannot carry in public unless you prove you have some special reason. Maybe a cash business, maybe a documented threat, maybe a judge liked your story. Bruen said no. If you are a normal law-abiding adult, your right to carry for self-defense does not depend on begging the government for special permission. That was change number 1. But here's the crazy part. Bruen did not wipe out all permits. That is what most people get wrong. The court basically said, may issue systems with too much discretion are a problem, but shall issue systems can still survive. That means background checks, fingerprints, safety classes, and objective rules can still exist in many places. That is change number 2. Most people think Bruen meant no more permits. That is false. The truth is more complicated. The court shut the door on vague standards, but it left room for objective licensing rules. So if you hear somebody at the range say, the Supreme Court made permits dead, be careful. That is not what happened. Now this is where it gets interesting. After Bruen, states did not just give up. They rewrote their laws. New York, for example, passed a new package of carry rules. Some parts were blocked, some parts survived. And in 2025, the Supreme Court declined to jump in and stop much of that New York system. That means states still have room to regulate, just not the old way. So change number 3 is this. Carry permits became less discretionary, but not less important. In a lot of places, your permit still matters. Your training still matters. Your paperwork still matters. And if you move across state lines, assuming Bruen made everything simple, you could walk straight into a criminal charge. Let's imagine you're driving through a state you do not know well. You have a permit from home. You have your handgun locked the way you always do. You stop for gas, then food, then you step into a location that your home state allows, but that state treats differently. You think, I am legal. The Supreme Court expanded carry rights. Maybe, maybe not. That is why this matters. Well, let me break this down for you. Bruen did not create one big nationwide green light. It created a new legal test. And once that test hit the courts, 9 different kinds of gun laws started moving. If you're finding this helpful, imagine what you will learn in my next video about the exact words that can protect you when an officer asks whether you are carrying. Subscribe now so you do not miss it, because knowing the law is good, but knowing what to say under pressure is even better. Now let's talk about the part nobody talks about enough. Sensitive places. That is the phrase courts use for places where guns can be restricted. Think schools, courthouses, and certain government buildings. Even Bruen said some sensitive place bans can still stand. But after Bruen, states tried to stretch that idea way further. That is change number 4. Sensitive place laws are no longer automatic. The government now has to justify them with history, and courts are looking at them one place at a time. Here is what that means in real life. A state may say, no guns in parks, bars, hospitals, buses, churches, libraries, museums, stadiums, beaches, and private businesses open to the public. Before Bruen, courts often gave lawmakers more room. After Bruen, judges started asking, hold on, show me the historical tradition for each place. And the answers have been mixed. Some courts have allowed bans in parks and bars. Some have blocked bans in hospitals, public transit, houses of worship, and certain gathering spaces. In one Florida case, a federal judge even ruled against the federal ban on carrying in post offices. That was not a nationwide ruling, but it shows how much old assumptions are being challenged now. That is change number 5. Location-based carry bans are being sliced apart. Not all at once. Not nationwide, but piece by piece. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Do not miss how important that is. Before, many gun owners thought the hard part was getting the permit. Now, in some places, the harder part is knowing where that permit actually works. You can be perfectly legal in the parking lot, then step 10 feet into the wrong building and suddenly be accused of carrying in a prohibited place. Here's a hypothetical example to explain this. Say you're carrying legally under your state permit. You meet your wife at a restaurant that serves alcohol. After dinner, you walk through a city park for a local event. Then, you stop at a bank ATM on the way home. In your mind, nothing changed. Same gun, same permit, same night. But under these new court fights, each stop can raise a different legal question. That is why I keep saying this is not one law. It is a chain reaction. Now let's go to age limits, because this is the part that shocked me. For years, a lot of people assumed states and the federal government could draw a bright line at age 21. But after Bruen, younger adults started winning some major cases. That is change number 6. Some under 21 carry bans are falling. In Minnesota, for example, the state could no longer enforce its rule blocking 18, 19, and 20-year-olds from getting a public carry permit after the Supreme Court let a lower court ruling stand. That did not create a nationwide rule by itself, but it mattered a lot inside that region, and it sent a message to other courts. And here comes change number 7. A federal appeals court struck down the old federal ban on licensed dealers selling handguns to adults under 21. Again, that does not instantly rewrite every rule in every state tomorrow. But it shows how powerful the Bruen test has become in age-based gun cases. Most people think adulthood starts at 18 for some rights and 21 for others, and courts can draw the line however they want. But the new question is different. Is there a real historical tradition for that restriction? If the government cannot show one, the law gets shaky fast. Hey, 73% of people watching right now are not subscribed. Do not be part of that group. Join the people who get these updates before they turn into expensive mistakes. If you want straight talk without the legal fluff, hit subscribe right now. Now let's talk about the group-based bans, because this is where a lot of viewers get confused. Some people heard Bruen and thought every ban on possession was about to collapse. That did not happen. Change number 8 is about who the law can disarm. In Rahimi, the Supreme Court said the government can temporarily disarm someone who has been found by a court to pose a credible threat to another person's physical safety. That case involved a domestic violence restraining order, and the court upheld the federal ban in that situation. Why does that matter so much? Because Rahimi told lower courts something very important. The government does not need to find an old law from 1791 that is a perfect twin. It only needs a good historical match. The court pointed to old surety laws and laws against going armed in a threatening way. In plain English, the court said America has a tradition of restricting armed people who clearly threaten others. So if you were told Bruen means all prohibited person laws are dead, that is wrong. Rahimi pulled the brakes on that idea. But wait, there is something even more important. Rahimi also made the Bruen test more flexible than many judges first thought. That means some laws the government was losing right after Bruen may now be easier to defend. You can already see that in cases involving dangerous persons. And as of this year, the Supreme Court also refused to take at least one challenge from a nonviolent felon, leaving a lower court ruling in place against restoring gun rights in that case. So what is the real takeaway? If a law is tied to a clear finding of danger, it now has a stronger chance of surviving. If it is broad, vague, or badly supported by history, it is more vulnerable. Now for change number 9, and this one trips people up because it is not really a Second Amendment story. It is a power story. Who gets to make gun rules, and how far can an agency go without Congress speaking clearly? In the bump stock case, Cargill, the Supreme Court said the federal agency went too far by treating bump stocks as machine guns under the existing statute. The court did not say bump stocks are protected by the Second Amendment. That is the mistake people make. It said the agency could not stretch the words of the law that far on its own. Then, in the ghost gun case, VanDerStok, the court went the other direction. It said at least some weapon parts kits and unfinished frames can still be regulated under the federal gun statute, especially when they are close enough to completion that an ordinary person can turn them into a working gun pretty fast. Read that again in plain English. One accessory rule fell because the agency overreached. Another rule survived because the statute was broad enough to cover the items. That means this 9th change is bigger than just bump stocks or ghost guns. It means future gunfights will not only be about the Second Amendment, they will also be about statutory text. In simple terms, what did Congress actually ban? And did the agency stay inside those words? Here's what most people get wrong. They hear Supreme Court pro-gun ruling and assume every gun case gets easier for gun owners. Not true. Some rules got weaker, some got stronger, some just got harder to predict. So let me sum up the 9 quiet changes for you. Special need carry permits are out, objective permit systems are still in, sensitive place bans now get tested place by place, private property default no carry rules are under heavy attack, broad public place bans are getting split up and partly blocked, under 21 carry restrictions have weakened in some regions, under 21 handgun sales bans have taken serious hits, dangerous people under certain court orders can still be disarmed, and agency-made gun rules now live or die based on the exact words Congress used. This information changes fast, really fast. The next big ruling could shift these lines again before most people even hear about it. Subscribe now so you stay ahead of the next update instead of learning about it after a traffic stop, a denied purchase, or a criminal charge. So what is the one big takeaway? Do not trust old gun law advice, even if it came from someone who means well. The Supreme Court changed the test, and that new test is still shaking loose changes all over the country. Pause. If this helped you, hit subscribe and send this video to one friend who carries, hunts, keeps a home defense gun, or just wants the truth. I spend the time digging through these rulings, so you do not have to. And one final simple reminder. Laws are different from state to state, and court rulings can be narrow. So before you carry, buy, or store a firearm based on something you heard online, check your local law or talk to a qualified attorney.